Ken Vercammen of Vercammen and Associates, who has offices in both Edison and Cranberry, to speak with us tonight. Thanks for coming.
Thank you, West Windsor Library and the Mercer County Library System. My name is Ken Vercammen, and I'm here to try to educate people as best as possible on wills, probate, and why it's kind of a call to action. So many times people ask me when I would see them around town at Elks Club or municipal meetings. Why do I need to have a will? Doesn't everything go to my spouse? He goes, yes, but both of you aren't going to die forever. Both of you are not going to be in good health forever. Let's say if you have children, don't you want to make it easier for them? People, no one is required to have life insurance, but if you had young children, you'd be foolish not to have life insurance. So for example, if someone does not have a will, the procedure to distribute assets becomes much more complicated. Let's say like someone passes, their spouse is gone, and there's 4 kids. Well, it requires all the kids to agree upon who's going to be the administrator if there's no will. And the ones who aren't going to be the administrator all have to sign a renunciation form in front of a notary and have that filed for a fee with the county surrogate. Well, when the state was closed down last year, that became very difficult to do. And again, sometimes you get the kid that says, no, I'm not going to sign the renunciation. Well, if all the kids won't sign a renunciation, then a complaint in order to show cause has to be filed with a Superior Court judge asking that someone be appointed, in the family to be the administrator. And, again, whenever you go in front of a Superior Court judge, you're probably spending, $3-4 grand, and everyone has to be notified. A $400 will would avoid that kind of issue. I'd say number 2, if there's no will, or we sometimes say when people like try to use cheap forms and they're not signed properly or done properly, then in addition to having to go through with this administration and renunciations, it requires the administrator to take up what's called a surety bond. Fees are $1,000, or more per year, and sometimes people can't get bonded because of their history with finances and not being creditworthy. So again, without a will, they have to take a surety bond. I'd say number 3, state law determines who gets your assets, not you. And more people are saying, listen, do I have to give everything equally to all these kids? How do I have to distribute my assets? And I usually say, let's try to make things as easy as possible. Okay. Now, if there's no spouse, no close children, who gets the money? Or close relatives, blood relatives. The state of New Jersey. Who would want to work their whole life to have the state of New Jersey get money? Most people would rather think of, well, listen, if I don't have close blood relatives, I'd rather have a charity, my church, etc. get the money rather than the state. If people have minor children, a total stranger determines who gets custody of minor children, who's a Superior Court judge. I'd say, and you lose the opportunity to reduce, some types of taxes or expenses. So the bottom line is, when loved ones are grieving, they shouldn't have to worry about one more thing. And we see that when there's no will, it often causes aggravation, fights, sometimes lawsuits amongst the family. So, you shouldn't put, if you don't have a will, you shouldn't burden your family with one more thing. Get it done. We've never had anyone in the 35 years I've been an attorney, after doing a will, someone says, oh, I wish I didn't do that. Everyone's like, I'm glad I finally got that done. My son's 40 years old. I've been putting it off for 40 years. My son's 50 years old. I should get it, done now. So, don't cause more problems by not, having things properly done. So, sometimes you have kids, grandchildren that are minors. Well, you want to set up a clause within the will that they don't get money when they're 18. Let's say, what do 18-year-olds do with money? Well, they certainly don't invest it wisely. They take the money, they go to Seaside, they play games, and they blow it. Now, I also tell people, beware of these online forms. Yeah, everyone wants to save money, but the problem is, oftentimes people don't sign it right, or it doesn't really contain what they want. So don't, where it says, one size fits all are valid in every state, it may not be best for the state that you were in. We share the story. You can watch a YouTube video on how to do your own electrical work. You can try to do your own electrical work, but if you don't do it right, then your house burns down. Let's say you can try to do your own plumbing work, but if you don't do your plumbing work right, then the upstairs bad water leaks throughout the house. Now, also, I'm going to discuss during the program, make sure that the will has a clause that says no bond is required. Now, believe it or not, things got more efficient and easier to do in the past year. Who would think? What did COVID do? Well, it made us think. Okay, how can we make it easier for everyone to do things? The old way, we would schedule an appointment with someone, then they would get a form to fill out, like when you're in a doctor's office, and spend all your time filling everything out. And instead, what most law offices started doing is, instead the office would contactless would email a short questionnaire. Let's say and tell the people, okay, what you're going to do is you're going to type in who's your name. You're going to type in who's executor 1, who's executor 2. You're going to type in who's going to get your things and who would get your things if that person passes away. If there are minor children, who would be trustee for the money and who would be the guardian for the people. Then, to make it easier for people, they email back the form to the attorney. The attorney then calls everyone back. It doesn't require people taking off half a day of work to meet with an attorney during business hours. Then, after the attorney explains what the fees are, the attorney prepares the documents, and then the attorney will typically now email the document out so someone can print it, and if it's correct, there's instructions on how to sign. The other reason why we're emailing it out, to make it easier for people, let's say in a year or two, someone wants to make a change to their will, they're simply switching around who's executor number 2. Well, they don't need to come into our office and sign papers, etc. Pay an attorney. We send them the Word document that they can change themselves. We've been hearing, hey, we want people to stay safe, but we're also trying to make it as simple as possible for people. I wish we would have had this, 5 years ago, where we would email out the form. And it made it easier because there was less spelling errors. I couldn't read people's handwriting, or they would have, their last name would be Gosh Gagarian, but then the spouse's name was Subrahan, and then the other relative who was the trustee would be a different last name. Now, we'll go into the program, but how do people then sign the documents? Well, when everything in the state of New Jersey was closed, what was open? The UPS stores were open, and the UPS stores all had notaries. So people said, hey, wait, this is easier. Now to sign my documents, I don't have to take off time from work. They don't have to, people would say, hey, I work in the city, or I don't get home till after 6 o'clock. Well, you can sign your documents on the weekend. You can sign your documents after hours because the UPS store is open. So, we're trying to make things as easy as possible. So, what are some of the things that you're going to be need to put on the will questionnaire? Well, basically, you're going to, as I said, you type in name, who's executor 1, who's executor 2. Now, the other important thing that we touch upon is the executors. Now, before I go further, sometimes people, hey, they only work through their iPhone. Can they get one of their kids to type everything on their laptop? Yes, they can, but under rule RPC 1.7, we got to worry about conflicts of interest, so that we need to actually talk to the person who wants the document done. We always get calls. Mom wants to have a will. Grandma wants to have a will. Okay, fine. I'd say we'll email the questionnaire out to you, but we're going to need to talk to them before we start it, because they have to say, yes, this is who I want here, this is who I want there. It can't be whatever my daughter wants, whatever my kid wants. It goes, no. You got to specifically tell us over the phone what you want. Now, let's talk a little bit about executors. Executors are one that handles the estate administration. Now, in other states, probate is very, very complicated, very, very expensive. New Jersey is the easiest state. Currently, to probate the will, all that the surrogate's office needs is death certificate, original will, check for about $140. And since the surrogate is still not open to the public, we have to have the people fill out the surrogate's information sheet ahead of time, and then we send it in. When the surrogate's office is open to the public, the people can just walk in and fill it out while they're there. Now, executors. You always want to have an executor 1 and executor 2. You never want to have joint executors because it really creates twice as much work. You could have identical twins that live in the same house, but when you have joint executors, that means that when they go to the bank, 2 people have to go to the bank. Then every check got to be signed by 2 people. When the house is going to be sold, 2 people have to sign the listing with the realtor. Then 2 people have to sign the contract for sale. 2 people have to sign the addendum. 2 people have to sign every form. 2 people have to sign the deed. Why create twice as much work making 2 people do everything? The idea is trying to make it as easy as possible when people are grieving. Now, the other reason you don't want joint executors is sometimes you get 2 people that don't agree. I had brothers that hate each other. They couldn't agree upon what color the sky was. Brother number 1 says the sky is blue. The other one says, no, the sky is gray. You're stupid. You've always been stupid. There's only one president of the United States, not a co-president. There's only one captain of the ship. So you have an executor 1 and an executor 2. Let's see. So then, people are, and we ask for real estate. The attorney needs to know what real estate you have in New Jersey, what real estate you might have in other states. And then New Jersey, by the way, did away with a lot of the taxes. They did away with the estate tax, New Jersey estate tax, 2 years ago. A couple years ago, the estate tax started at assets over $675,000. That's not a really big chunk of money. So New Jersey did away with the estate tax. There's no inheritance tax if it's going to children, spouse, grandchildren, stepchildren, parents. If it's going to brothers or sisters, the first $25,000 is tax-free. If it's going to charities, bona fide nonprofits, there's no tax. So we as attorneys, I don't need to know specifics on account numbers and account statements. And we do the documents. People will then contact me and say, "Oh, you didn't list any of my assets in the will." And I said, "Well, you don't need to list any assets in the will, because the will only takes effect really on the day you pass away. So unless someone knows the day they're going to die and what they're going to own," it goes. That's why a will is kind of a fluid thing. It just says whatever I own goes to this person, this person, this person, this person. Now, keep in mind though, you could have the best will around, but there are certain assets that do not pass by way of will. Let's see. So examples of those are when a house is owned husband and wife. That's called tenants by the entirety. So that means that if it's owned husband and wife, if one of the two passes away, automatically goes to the surviving spouse. There's no need for a new deed. Nothing needs to be done. So that asset passes by title. bank accounts passed by title when they're POD, payable upon death, joint tenancy, CDs that are POD, payable upon death. A will can't change that. So, if you have if mom puts her daughter on accounts that says joint tenants or POD, but the will says everything's divided amongst my 3 kids. Well, if mom passes, it goes to the name of the person who is on that account. It doesn't go under the will. Certain assets pass by way of contract. Examples of those are IRA, 401k, life insurance, annuity, anything that sets forth a beneficiary. So it's also a good idea after you do your will to get a printout of these different accounts that list if there is a beneficiary. And you get the printout, you can put it in your will file. This way, if there's any assets that have a direct beneficiary, it's in the will file. So let's say if someone has real estate in another state, then after the will is probated in New Jersey, they have to go through something that's called ancillary probate in the other state. So let's say someone owns their house here in Mercer County, but they also have a Poconos house that they go in during the summer. Then you have to go, to the Register of Wills in Pennsylvania in that county, Lackawanna, Luzerne, Carbon, to go through a procedure there. So again, the will can't change who's getting life insurance. Get a printout. Now, the will then lists who's getting your stuff. Let's see. And then there should be a clause that says if that person passes away, who gets their share. I call it the typical basic family will. First it goes to spouse, then it goes to kids. If any of those kids shall predecease, it goes to their children, who would be the grandkids. If they don't have any kids, no grandkids on that side, it goes to the survivors. And then if there's only 2 kids, sometimes someone have a clause saying, if these all pass away, it's going to, my sister, or it's, you specify could go to a charity. Now, talking about charities, let me talk about something that's called specific bequests. What a specific bequest is where someone's leaving either a percentage of their estate or a specific amount to either an entity or a person. So an example of a specific bequest is someone says, okay, I leave $10,000 to my church, St. Joseph's. Let's say I leave $10,000 to University of Scranton. I leave $5,000 to American Cancer Society, New Jersey unit. Now, if you're leaving money to a charity, you want to be specific, because sometimes there have been lawsuits between charities fighting over who's getting the money. So, if it's St. Francis Church, well, which one? And sometimes we put clauses that says, if that charity ceases to exist, either that share lapses or who would get that share. Sometimes people leave a percentage of money to a $5,000, $10,000, $20,000 to a grandchild. Now, more and more though, people are saying, do I have to give it to my kids? I go, no. Let's say, people are saying, my kids are already doing okay. They have a house, and if they get the money, they're going to go and buy a boat or luxury items. I'd rather put it towards, my children, my children's kids, my grandchildren's college, because, hey, we know how much, college costs. The cost of College of New Jersey or Rutgers, and they're state schools. You're trying to go to a private, university like University of Scranton or St. Peter's, substantially more. So some people are saying, no, I'm going to give it to my grandkids, and put it towards their education. If they want to goof off, then okay, then they're not getting their money. So again, it's your right, as long as you're competent, to do what you want with your money. Now, last year, one of the clients said, do I have to treat all my children equally? One of my kids we don't hear from much. I go, well, tell me about that. He goes, well, he lives on the West Coast, and we never hear from him at all. He goes, well, let me ask you a question. Did he get a card or a call on Mother's Day? She goes, no. Did you get a card or a call on your birthday? No. Did you get a card or a call on Christmas? No. So a year's went by, you haven't heard from this guy? No. Well, why leave him anything? If he doesn't care about you, and I also say, that person that doesn't care about you while you're around is usually the biggest troublemaker when someone passes away, because they're the first person pounding on the door saying, where's my money, where's my money, where's my money? And it's kind of sad when these people don't have wills, and they're shocked to find out that the person that hadn't been in touch with anyone for a year, they get the equal share as the one that drove mom or dad to all the doctor's visits, cleaned up after mom, helped mom, was there for mom, when they needed help the most. So again, it's your call on what you want to do. Now, also with specific bequests, sometimes we have what we sometimes call the reverse specific bequest. And that is, I leave nothing to name a person. We don't leave them $1. We don't give any reasons why. Just, I leave nothing to that person, period. Period. Nothing more. Now, I also mentioned it's a good idea in our wills. We have a clause that says no one under 21 gets any money. It's going to be held till they're 21, but can be used for support, college, etc. When people have minor kids, for both tax and protection reasons, we usually say, okay, if both parents pass, the money's going into equal trust for the kids, but they don't get the money outright. They get some when they're 22, some when they're 25, the balance when they're 30. But, the monies can all be used by the trustee to pay for private school, but it protects the monies from creditors. It protects them from themselves and protects them from whoever their friends are, to try to prevent their friends from interfering. Because I know, for example, if you don't have these kind of wills and, parents, suddenly pass, kid gets money when they're 18, 19 years old, all their friends are going to know they inherited money. And, the guys have a girlfriend, the girlfriend says, oh, you haven't bought me any nice jewelry for a while. Let's say, so people are influenced by the others. We have to protect them from their others. So on the other hand, let's say someone graduates college, they're 21 years old, and they go to the trustee. He goes, hey, Uncle Johnny, listen, I graduated from Susquehanna, and I got a job, and I like to buy a condo by where I live, so I'm not paying rent. Uncle Johnny's a trustee, and Uncle Johnny can say, that makes sense. Let's say I'll fund it. I'm not giving you the money outright. We'll pay for the condo. Let's say a person says, okay, I'm finished with college, like money for grad school. Absolutely, because that's what's in the will, to pay for health, education, maintenance, support. On the other hand, someone's 20 years old and says, college is so stressful. I need to take time off, and I'd like to take a cruise across the Caribbean with 10 of my friends, and I need like $50,000 for that. Uncle Johnny's going to say, no, go. If you want to drop out of college, that's your call, but I'm not taking your parents' money. The money your parents worked hard so you can goof off with your friends and not work. Because a lot of times, people are, you got to protect them. We did a program for the American Bar Association, and the program was called Estate Planning for the Dysfunctional Child. And we also called it estate planning for the problem child. Because sometimes, we're not talking about children that are 20, 21 years old. You could have a 34-year-old that they don't work. They're just getting by, and all they're doing, they're waiting for the day mom or dad dies so they can get their chunk of money. Well, you want to protect them so they don't blow it right away. We handled a probate matter for an executor where mom had set up the will where money's going to one kid wouldn't go to him. It was going to go into a trust for his benefit. The guy was 45 years old, but he was also an alcoholic. And, listen, we know if an alcoholic gets $100, they'll spend $100 worth of booze. If they get $1,000, they'll buy $100 worth of booze and blow the rest and give it to their friends. So the idea of setting up what's called a testamentary trust is the money be held by a trustee, usually, a family member that's strong. That way the monies can be used to pay for the alcoholics, medical coverage, used to pay for the alcoholics' rent, used to pay for car insurance. They were buying cards at the ShopRite so that had money for food, but rather than giving them the American Express cards or Visa cards that can be used for booze, but it also protects from creditors. It protects from the IRS, and it protects from even alimony. So the estate that we helped out, there was a lawsuit filed by the guy's ex-wife saying, okay, I'm owed all this alimony and I'm owed some other things, and Judge, I'm asking you in family court to compel the trust to pay money to me. And I represent the estate, and the judge agreed with me. He goes, hey, the reason why people set up these testamentary trusts is to protect the money, and it gives the trustee sole discretion to spend the money or not spend the money. So it's something that down the road you talk to the attorney. You want, people. In my experience, I know that people that have, kids with special needs know that they got to protect their kids, and sometimes they'll have what's called the special needs trust, set up, for, so the kid doesn't lose their entitlement. But sometimes we also got to think, okay, do we want this kid or grandkid that is a slacker, that doesn't work? They're fired from job to job. Everyone's against them, and so they can get money, then spend their time just going on trips and blowing it. So, the whole idea is doing what's best for everyone. Now, think of the trustee is the one who holds the money. When there's minor person, the guardian holds the kids. So when someone has minor kids, sometimes the question is, okay, who do you want to hold your kids if both of you pass away? And people sometimes put off doing their documents. Oh, I can't decide that. It's so tough. It's so difficult. It goes, no. It's not that difficult at all, because there's only a few people on the whole planet that could even be considered to be guardian for your kids. Let's say, yeah. So there's no one best to watch your kids. But who do you trust to watch your kids for the next 2 weeks if you couldn't come home today? I'd say, and usually they'd say, oh, well, my mom, my dad, but they're getting older. Yeah, but they're best for right now. There could be a change a year from now, but without having that, the person who you don't want as the guardian for the kids can go in front of the judge and say, I want to be the guardian. I want to be the guardian. I want to be the guardian. Now, there are a couple of changes in the law. I'd say under the old law, I'd say person signed, then two witnesses signed. But then one of the two witnesses the executor had to find one of the two witnesses and have the witnesses sign, one of them signed paperwork saying they were the witness to the will. It's called the proof of the will. And I remember when my grandmother passed, and we found one of the witnesses, and that lady used to work in a law office where the will was prepared. She goes, yeah, I used to work there. My fee's $500. I go, my dad goes, $500, we're not paying you $500. Lady goes, okay, good, go get the other witness. Well, she's dead. Yeah, my fee's $500. Now, we could have said, forget you, lady, we're going to go in front of a superior court judge, but that would have cost us, $2, $3, $4 grand, so we had to pay this extortion. So, if you already have a will done, make sure it's a self-proving will. See, now, the reason why I bring that up is I see some of these cheap online forms are not self-proving wills. So that means that you got to find one of the witnesses. Well, if you can't find the witnesses, then you got to go in front of a judge. So how much money have you saved if you did it yourself, where you got to then spend $3 grand to do it? Same thing. Some of these like cheap online forms don't have a clause that says no bond required. So then, well, yeah, you saved the $400 on doing the will, but then you got to pay $1,000 for the bond requirement. So our whole idea is trying to make things as easy as possible. If a beneficiary is receiving Social Security benefits such as SSI, SDD, you want to let the attorney know, because sometimes we don't want to leave money outright to them because they'll lose their entitlements. You provide information. You're meeting with the attorney. We use the word online, but it's over the phone. There was a big thing. We're meeting with everyone through Zoom, etc. Well, I found the clients don't need to see my smiling face, and because then they knew that then they had to look nice and put on the ladies wanted to put their makeup on, and guys felt obligated to dress up. Well, no one needs to dress up. So the attorney, the information is provided to the attorney. The attorney prepares there's different kinds of wills. So so there's a will like parents with minor children where we set up this testamentary trust for the minor kids. Sometimes we set up the testamentary trust. They're not minors, but they're kids that have issues. Sometimes they're parents with no spouse. So kids, grandkids, who's going to get it? Sometimes we set up a will that sets forth it was common when the New Jersey estate tax was very high, but it's now common with second marriage situations where someone says, listen, I'm not leaving everything to my new spouse because they could have a new will done after I pass, and then everything's going to go to their third spouse. Or monies that they inherit from me could then be tapped to have to pay for nursing homes. So sometimes we do wills that say, it's called a spousal trust in the will. Everything's going into a trust within the will for the benefit of that spouse, but to protect it from Medicaid. That spouse can't be the trustee. They can't have control over the trust. It's usually a child, grandchild, or other family member that becomes the trustee. That way, the money's held for that spouse's benefit. They're allowed to withdraw 5% or $5,000 per year, whichever's greater. Plus, the trustee can expend as much money as is needed. But on the other hand, when that spouse passes, then it goes to the children or grandchildren. And of course, there's the catch-all where it's not going to kids or grandkids, and people decide who's getting it. We had a nice little old lady, and she didn't have any blood relatives here in New Jersey. She had some, her husband died, she didn't have kids, her two sisters died, and she goes, you know what? Okay, I'm leaving some money to my neighbors, some to my church, some to my hairdresser, because these neighbors were nice to me, not because they thought they were going to get a windfall when I died, that they were going to get put in the will, but they were nice people, and they were the ones that called me up to make sure that if there's a snowstorm, Helga, do you need anything? Mary, how you doing? We haven't seen, your car hasn't moved. Are you okay? Do you need anything from the store? We're going to shop right. So again, it's all part of doing the planning. So what are some of the clauses in the will? Well, debts and taxes paid. 2 specific bequests. Then where's the money going? Distribution to spouse. Sometimes trust for spouse, sometimes trust for kids, distribution to kids, or else who's getting the money. Always a clause if there's beneficiaries under 21, who's the executor, who's the trustees. Always a clause that says no bond required, general clauses, and then always make sure it's a self-proving will. Now, the people typically nowadays are signing their documents either at in front of a notary in the area, at the UPS store. A spouse can be a witness to a will. Let's say if it's second marriage, I don't recommend it, but a spouse can be a witness. There should be someone else who's kind of independent, but the spouse should not be the witness to the power of attorney. That's a different document, because typically most people make the spouse as what's called their agent. Now I mentioned special needs trust for when there's minors, and a will is done typically on a flat fee basis. Now, don't put after the will is done. The will is your property, so it's a good idea to put it in a place where executor 1, executor 2 can get to it. Don't put it in a safe deposit box because people can't get to stuff easily, and certainly they couldn't get to anything last April when the banks were closed and you couldn't get in without a special appointment, etc. So the idea is at a place, people go to Costco, they buy a fireproof box and it's there. Because the next documents I'm going to talk about, power of attorney and living will, those are documents you might need on a weekend, and certainly the bank is not going to open their doors in their safe deposit box on a Saturday afternoon or Sunday afternoon so you can get it. Don't put off stuff. Let's say get your documents done, and it's kind of doing the responsible thing. You don't need to, read about wills, trusts, estates, things like that, because you want to go to, an attorney who's done this before. We had this gentleman that he was an old school guy, and his estate at the time was subject to an estate tax. And I said, listen, here's a way I can do it where you don't pay any estate tax at all. He goes, well, I'd like to read it more up on it. He goes, Mr. K, let's see, you were an engineer. You don't need to read about law stuff. I went to law school. I take law seminars. I'm a speaker for a New Jersey State Bar Association. You don't need to read about this stuff. I said, when I need a knee surgery, I didn't read anything about knee surgery. I called the Rutgers track coach. Hey, who's the best guy you got for knees? Went to that doctor, and I said, doctor, you've done this before, right? He goes, Kenny, I could do this almost with my eyes closed. Okay, good. But this man wanted to read up. Well, he put off. Don't hear back from him. 2 years later, the family calls me. Cal died, and there was some communications in his papers. Do you have his will? I go, no, he never did one. He kept on wanting to read. So the family got hit with tens of thousands of dollars in estate taxes they could have saved by having the attorney do this stuff. One of the things I do want to touch upon is trust. Now, New Jersey is a probate easy state. To probate the will, again, you need a death certificate, check for about $150. The original will, you fill out some papers, the surrogate sends you the papers, and you don't hear from them again. They're not following up on you. Other states, so probate's very complicated. So my mother-in-law used to call me every other year, and she'd say, Kenny, I need to come in. I want to come in and get a trust done. I said, were you watching Susie Orman? She goes, oh, yes. I love Susie Orman. So Susie Orman is exactly right. If you live in New York, California, Florida, where probate is very complicated and very, very expensive. But in New Jersey, there's no reason why you need to have a trust when a $400, $500 will will do the job for you. Now, some people, they say, I have a gentleman right now. I want to completely avoid probate. I know it's easy in New Jersey, but I want to put the houses into a trust so the day after I die, it goes directly to my daughters and they don't have to even go to the surrogate's office. Okay, listen, Mr. J, and it's going to be $4,000 because we got to retitle all these assets right now. He goes, okay, I want to do it. Okay, listen, but I'm always like 100% honest with everyone. What's a revocable trust? Well, a revocable trust is you can revoke it and change it at any point in time. Now, there are trust salesmen that say avoid probate. Probate's a devil. Well, listen, probate in New Jersey is easy and inexpensive. You're doing a trust, you're paying $3,000, $4,000 or $5,000. 2, a revocable trust does not protect assets from nursing home, taxes, Medicaid, creditors. The trust salesmen sometimes say, a will is a public record. But a trust is private, but this, people aren't leaving their money to the Ku Klux Klan or crazy people. So why would you need to hide what's in your will? Let's see, if someone does want to have a trust done, put their house into a trust, okay. There needs to be a deed, affidavit of title, seller's residency certification, affidavit of consideration. You're paying, a check of about $150 to the county clerk. There's the county clerk cover sheet that has to be done. So now, what are some of the trusts that people do in New Jersey? Well, some people set up an irrevocable trust, not only to avoid probate, but to protect their houses or assets from Medicaid. So that's what an irrevocable trust is. But you have to then transfer the assets into the trust. The trust is going to own the house. The trust is going to own your bank accounts. Then there's a 5-year look back, 60 months. And then on top of that, you can't be the trustee. But sometimes setting an irrevocable trust is better if you want to protect assets from Medicaid rather than just giving your assets outright to your kids. And why would someone want to spend $4,000 to do that? Well, listen, if you give your assets outright to your kids, then your kids could blow the money. Your kids can kick you out of the house. In one instance, old man M decides to put half the house goes to his son, half the house goes to his daughter. Then half his assets go to the son, half the assets go to the daughter. Okay, he goes, okay, now I just got to live, 5 years and everything's protected from Medicaid. Well, his son dies. Who now owns 50% of everything he ever saved up? His daughter-in-law or ex-daughter-in-law, who can then get remarried and give it to everyone else. So, someone's in a house, they could have a falling out with a kid. The kid could go into financial problems. Sometimes people have bad marriages, and the spouses try to get money. So, again, it's something that you sit down with an estate planning attorney who does this, and again, you save money sometimes by spending money, but make sure it's someone who's done this before. I'd say I don't know why people went to see me when I was a young attorney, because I knew nothing. I'd say I did it right because I was working for a law office, but again, you want to go to someone that it's not their first case. Now, a will is good if you move to another state. I'd say a will is good 20, 30 years from now, but you may want to update it in the event that there's any kind of changes that you can think about. I'd say now, so if you do move to another state, I mentioned the word a will is still valid, but you may want to have changes. You do want to have a new power of attorney every 5 years or so. I do also want to point out that our office typically charges a consult fee. Most experienced attorneys do charge a consult fee. I do, as a courtesy for people who were nice enough to take the time out to listen to our programs, that within 30 days of the program, if they contact our office, we do a free consult. Someone fills out an information sheet. Really it's the will questionnaire, and then talk to them and go over what I would recommend. And it's up to someone what they want to, they don't have to, no obligation, they don't proceed further. Okay. And I'll try to, put my contact information in the chat later on. Now, I mentioned after you sign your will, only the original will can be admitted to probate, not a photocopy. I'd say, can people provide copies of the will to people? Yeah, it's common where my clients sometimes will get a family member to scan the will, so everyone's on board with what's going on. For the power of attorney, and we're going to go into power of attorney shortly, I recommend that the power of attorney be scanned and but basically it's sent to you, so you have it on your phone, but also you scan it and you send the power of attorney to your financial planner, to the accountant, to the banker, the people, life insurance person. This way it's on their record, so if heaven forbid, all of a sudden someone becomes disabled or their power of attorney needs to be used, the financial planner already has that information. Okay, let's now talk about the power of attorney. Think of the will transfers your assets if you pass away. What the power of attorney will do is you're selecting someone while you're alive, typically a spouse or family member, to make sure that your bills are paid, your assets are taken care of, and they can speak on your behalf. Where they could sell, if a house needs to be sold, there's a clause in the power of attorney to sell real estate. A clause in the power of attorney to open up accounts, close accounts, do the banking for the person. Yeah, I mentioned beware of online will forms. Also be aware of online power of attorney forms, because a lot of banks will not recognize them. But there was a change in the law, by the way, that a lot of banks were giving people a hard time. No, it's not on our form. You got to be on our Wells Fargo form. Well, I'd say that became a problem, because by that time the person wasn't able to sign a new power of attorney. So, I'd say the New Jersey legislature came up with a new law to say, if the power of attorney makes reference to the power of attorney statute, if the institution, the bank or financial planner does business in New Jersey, they have to honor it, otherwise they're in violation of New Jersey regulations. But the power of attorney has to make reference to Section 2 of PL 1991, C95, C 46:2B-11. So, I'm pretty sure these cheap or free online forms don't have that. And if the power of attorney wasn't done right, isn't recognized, then the family has to go through an expensive and complicated guardianship to declare someone incapacitated and get a court order to be able to sign there, and then to get a court order to sell a house, which also involves expensive appraisal. So part of what we're doing, in a way, is trying to save money for people. The power of attorney is effective either right away or only upon disability. 95% of people now say, listen, I want it effective right away, rather than only upon disability. Because if it's effective only upon disability, you got to get a certification from a doctor, and then the banks still give the people a hard time, and it creates more work. So I recommend the power of attorney be effective right away. If it's effective right away, it's called the durable power of attorney. It's effective right away, and it stays in effect even if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled pursuant to New Jersey statutory definition and the doctor signs a certification of disability. Now, I had a nice client come in, and I'm trying to explain this to him. He goes, Kenny, listen, I'm a carpenter. You're using legal terms on me. Explain to me in carpenter terms. I go, oh, that's easy, Fred. Okay. Effective right away, that means that your son because your son is your power, your son can steal your money right away. If effective only upon disability, he has to get know from a doctor before he steals your money. Knowing that, you trust your son. He goes, I trust my son with my life. He goes, then make it effective right away. You trust your son. And, so again, I mentioned the power of attorney. You want to have that signed, and then give copies to your financial advisor. This way, it's on record, and it's important because people wait till the last minute. And we get calls a couple times a week. I need to get power over mom, dad, Uncle Joe, grandma. I goes, no, you can't get power of attorney over anyone. They have to affirmatively say, this is what I want. So, again, I get, call, I need to get power of attorney over grandma. She has dementia. Well, listen, that the person who's giving the power of attorney, listen, I know some people can't type well, and the family types, but they got to talk to us over the phone, or in person, and say, I want to give the power to sign my bills, etc., to this person. If they can't do it, that person. If they can't express that to us, then I can't do it. I said, sorry, I can't do it. I mean, I can't, I got to only do what's permitted of me by the rules of court, etc. So my theory is I always want to do everything right. If I don't feel I can do it right, then I'm not going to do it. Just like on the other hand, if someone calls me up and says, oh, mom wants to do a new will, and give me 70%. Okay, fine. I need to talk to mom. Well, no, this is what she wants. No, I'm not doing anything until I talk to mom. Just like Johnny calls me up and he goes, Mom wants to sign the house over to me, but she can't come in. She got medical issues. Okay, and I help out people that can't get around much because of medical issues. But I need two things. I need the doctor to sign a short certification saying the person is competent to either do the will, power of attorney, deed, and I want to talk to him first before I start any document. So in this case, the doctor signs the certification, and then I get, and I talk to, mom over the phone. He goes, hey, mom, how you doing? Because I knew the family from grammar school. And she goes, it would be better if I wasn't on oxygen tank. Okay, mom, what do you want to do? She goes, I want to sign the house over to Johnny. Now, 80% of the attorneys would say, okay, great, good. I just made $800. Great, I'll do it. But me, I want to always do the right thing. Goes, okay, Mrs. B, let me ask you a question. Let's see, how many kids you got? She goes, I got 3. It goes, well, do you understand? If you sign the house over to Johnny, the other kids aren't getting anything because the only thing you really own is the house. Is that what you want? No. I want all my kids to be treated equally. That's what I thought. Put Johnny back on the phone. She said, no, I'm not doing a deed where you're getting the house. I also say sometimes people say, well, I trust Johnny. I know he'll do the right thing. He goes, of course he's going to tell you he's going to do the right thing. Of course he's going to say he's going to do the right thing. He's not going to look you in the eye and say, yeah, I'm going to screw my brother and sister. But a lot of times people, if she signs the house over to Johnny, Johnny could have the best intentions in the whole world. But if Johnny dies, all of a sudden his wife owns it, and she's going to say, screw those brothers and sisters. They don't deserve it. Okay, the last document we're going to talk about is the Living Will Advance Directive. Oh, and by the way, in the power of attorney, before I go, you have an agent 1, agent 2, just like executive 1, executive 2. Never have joint. Wills are not filed anywhere. A power of attorney does have to be filed with the county clerk if someone's going to use it to sell a house. Oh, also, we just this month we revised all our power of attorney forms to make reference to the New Jersey Care Act. So that was the one where someone can designate a caretaker. If someone goes into the hospital and there's you always want to have someone as the captain of the ship. That way, doctors, etc., have the first person to talk to. Because again, in sometimes we see that someone all of a sudden is hospitalized, and the person that wasn't involved all of a sudden barges into the room. They drive in, they fly in. All of a sudden, it goes, okay, I'm in charge now, and this is what we're going to do. Well, they can say no. Let's say mom had the power of attorney and living will prepared, and no, you're not the one in charge. The one in charge is the one that's been helping out all along and doing the dirty work, not you coming in at the last minute, trying to do inheritance protection. Okay, let's lastly talk before I have the financial planner come on. Let me talk about what's called the Living Will Advance Directive. So people remember or heard about the Karen Ann Quinlan case, where New Jersey was the first state to recognize the right to have feeding tubes removed. Then a decade or so ago, the case that went to the United States Supreme Court, the Terry Schiavo case, where the hospital doctors declared the person brain dead, but there was no living will, so the husband has to go to the court and say, listen, I'd like to have feeding tubes removed, and then the girl's parents went to court, opposing it, saying, oh, no, we know, there's always hope someone's going to come out of a coma after all these years. We spoke to her and her eyes twitched, and, that means she's hearing us. And the doctor said, no, that's an involuntary contraction. With the brain dead, we got the scan. Well, they spent hundreds of thousands of dollars, to go to the Supreme Court. So the idea behind the living will is so that you're making the decision ahead of time, so your family is not pressured and have to be put in that horrible position of the doctor saying, okay, should today be the day? Because I remember when a doctor asked me that one time, and it wasn't even a family member, but the person did not have a living will, they only had the power of attorney, And I remember the doctor saying, okay, should today be the day? And I remember saying, geez, doctor, I feel bad. Now, you know what the right call is for someone who's 92 years old, that's never going to regain consciousness again, never going to open up their eyes again. But you hate to be the one to say, okay, doctor, that sounds fine. Let's end the person's life today. Because I couldn't even do it for my sick dog years ago. So the idea behind a living will is you're already giving instructions to hospitals and doctors saying, listen, if I'm in a coma, irreversible condition, there's no hope for me, then let's not prolong this. Let's not have my family go through suffering. So we took language from the medical society's living will to indicate that, okay, Section 8, fluids and nutritions to be withheld or provided. That's feeding tubes. Let's see, 85% of people now say, listen, if there's no hope for me where I'm in a coma, and also I can't speak for myself, I don't want to have feeding tubes put on me. The next section is B, directives deal with medical treatment. That includes artificial machines. 99% of people say, listen, there's no hope for me, no machines, no respirators, no. Now, don't be concerned. It's not saying do not resuscitate if you have a heart attack and you're at ShopRite shopping. You know, the ambulance people are going to do what's medically appropriate, but it's where someone, again, is in the hospital and, you know, the doctor said, listen, there's no hope for this person. In the living will, you're typically having agent number 1, agent number 2. You don't want to have joint because that means two people got to make joint decisions. So the living will document is really for the family, not for you. And listen, sometimes people have a different person as their executor in their living will, because sometimes in a living will it might say, okay, this one child is better with money and finances. They work, as a broker. But I want this child to be the agent for the living will because they're a nurse. We also revised our documents to provide for language under the HIPAA law so that the doctors have a legal authority to speak to a family member, because without that legal authority, the doctor legally can't talk to you. And lastly, the living will has a section, organ donation yes, organ donation no. I recommend everyone do the organ donation yes. I'd say no matter what your age, what your health, you want to encourage more people to do it. I attended an interesting seminar put on by the NJ Sharing Network, which deals with organ donation in New Jersey. And I asked the question, I goes, hey, what's the maximum age to be an organ donor? And they said there is no maximum age. I go, well, what's good on an 85-year-old guy? And they said skin and cornea. He goes, well, I never thought about that. Gee, if I was in a fire, I'd rather have old guy's skin than the stuff that got burned off me. So again, it's something good to do. Probate in New Jersey is easy. The executor probates the will. They obtain a tax ID number. We send a notice of probate to the different beneficiaries, open up an estate account, pay the bill, liquidate the assets, pay the bills. Then once we know what sell the house, file the inheritance tax return, and then we prepare what's called release and refunding bonds. We send it to all the beneficiaries, say sign this, and as soon as everyone signs it, they get their money. If all the beneficiaries don't, and they also get an informal accounting. Usually it's copies of the checkbook ledger and the account statement so people know what money's there. If all the beneficiaries don't sign the release and refunding bond, then there has to be something that's called a formal account. So having said that, I'm going to now. I'm going to look at what the questions are in the chat, and while I do that, I'm going to ask I'm going to finish up. My name is Ken Vercammen. I'm going to come back, but I'm an attorney with main office in Edison. I also have an office in Cranberry. I was the prosecutor there for 9 years in Cranberry, and I live next door in South Brunswick. So thank you, everyone.